The Democrats want reforms of ICE, including arrest warrants. Chuck Schumer.
What Democrats want is exceedingly reasonable. We need to end roving patrols. That means arrest warrants and ending racial profiling.
I'm Rich Lowry of National Review, and of course, Democrats are pushing for a bunch of changes to ICE in order to support the stalled DHS funding bill on the Hill. And one of them, they want to move away from so-called administrative warrants and get judicial warrants for what ICE does. Now, sounds great, right? Who can oppose judicial warrants? A little unclear exactly what Democrats are after here. They're being a little vague, maybe deliberately so, or maybe they just don't know what they're talking about. But if we went to some maximalist change where you had to get judicial warrants for almost all the arrests that ICE makes, that would be a cataclysm. That would gut interior enforcement. And you got to believe that at least some Democrats know that would be the end result of this idea. So what I want to do in this video is, one, talk a little bit about what administrative warrants are. Then I want to talk about how long ICE has been using these administrative warrants and how and why they're lawful, and then talk about what a debacle it would be if we moved to judicial warrants in some big way. Now, an administrative immigration warrant is issued by ICE or some other DHS agency on its own. It's not signed off on by so-called Article 3 federal court or by a state judge. Instead, the agency itself. Now, not the officer who's going out to try to make this arrest himself, but a higher official who's attesting that there's probable cause for this apprehension. And what we're usually talking about is either Form I-200, which is a warrant for arrest, or an I-205, which is the form for a warrant for removal. Now, the left says, dear God, how can you be apprehending people just on your own say so? This is so un-American. This is Star Chamber stuff. But if we look, for instance, at the form I-205, the warrant for removal, you only get that final order of removal where they're coming in looking for you and arresting you if you've gone through an extensive process already. Art Arthur, the great Center for Immigration Studies, sets it out. As he writes, a Form I-205, warrant of removal/deportation, is only issued after an immigration judge, the Board of Immigration Appeals, a U.S. District Court judge, or magistrate court judge, or other designated official has issued a final order of removal or deportation in the named alien's case. On top of this, once you're arrested, all sorts of other due process kicks in. You can petition an immigration judge for bond. You can say, I'm not an alien. I'm not deportable. And by the way, in all this immigration enforcement, what we're talking about is a civil matter, not a criminal matter. These aren't trials to go and lock people up afterwards. We're talking about ascertaining people's immigration status, and if they're deportable, then deporting them and setting them free. Now, this kind of process has been in place for a very long time. Check out this Supreme Court case. This is the Supreme Court case of Abel versus United States. It involves a really famous spy case involving a guy named Rudolph Abel. We don't have to bore you with all the details here, except for say the FBI was on to him, then wanted some help from what was then the INS, not ICE, the INS. The INS goes into his room with an administrative warrant. What does the Supreme Court say about this? Statutes authorizing administrative arrest to achieve detention pending deportation proceedings have the sanction of time. It would emphasize a disregard for the presumptive respect the court owes to the validity of acts of Congress, especially when confirmed by uncontested historical legitimacy, to bring into question for the first time such a long-sanctioned practice of government. And the court continues, in the presence of this impressive historical evidence of acceptance of the validity of statutes providing for administrative deportation arrest from almost the beginning of the nation, petitioners disavow the issue below, calls for no further consideration. So this is the Supreme Court in 1960, saying that administrative warrants have a long pedigree. And you might think, oh, it must have been written by a right-wing justice, that opinion. No, it was written by Felix Frankfurter, who helped found the ACLU. And you might think also, well, this long ago decision from 1960, that must be a dead letter in the law. No, here's an Eighth Circuit decision from 2007. This is the case U.S. v. Lucas, and the court said the Supreme Court has upheld administrative warrants and has never held that administrative warrants must be issued by a neutral and detached magistrate. An administrative arrest warrant issued by a district director of the INS pursuant to a deportation statute led to a valid arrest in Abel versus United States. There, the court recognized a long-sanctioned practice and overwhelming legislative recognition favoring the propriety of administrative arrest. Then there's the matter of just the black and white letter of federal statute. Here's another piece for the Center for Immigration Studies. There's no provision in the Immigration and Nationality Act, no provision whatsoever for judicial orders, nor do they exist in any other federal statute. What the INA does specifically provide for is arrest of aliens with or without warrant for violations of the immigration laws, but the warrants authorized by Congress are not judicial warrants, and deliberately so. Why deliberately so? Because everyone rational realizes if you require judicial warrants for all immigration arrests, we're talking about millions of warrants that would have to be approved. So this would gum up the works in two ways. One, it would create a huge new burden on ICE agents and make their job totally unmanageable, and do the same for a lot of members of the federal judiciary. By the way, judges would have to be reviewing these applications day and night. There's a reason that sanctuary jurisdictions, some of them say, oh, we'll hand over this illegal immigrant to you, provided you have a judicial warrant, because they know it's very difficult to get a judicial warrant. And it's a way of them basically saying, we don't want to hand this person over. By the same token, on a larger scale, saying you got to get a judicial warrant for all these arrests is a way of saying, we don't want you arresting these people. This is a very telling incident from last year, by the way. A city official in New York, Brad Lander, went and interfered with an arrest of an illegal alien. And in an interview afterwards, here he is explaining what he was demanding.
So when they came up, I asked to see the judicial warrant for his removal. I made real clear I'll let go if you just show me the judicial warrant.
We shouldn't discount the possibility that Brad Lander just had no idea what he was talking about. It makes sense that someone who doesn't want an illegal immigrant arrested would demand a judicial warrant. And the Democratic Party writ large is now talking in these terms. So in this negotiation over this funding bill, if Democrats are demanding widespread judicial warrants for the arrest of illegal immigrants, the answer from the Trump administration and the Republican Party has to be no, no way, forget about it. I'm Rich Lowry, over and out.